Good morning and welcome. My name is Derek Lackey, and we are here to talk today about the Bill 64, specifically within Bill C-64, the protection of personal information in the private sector, new law in Quebec. More important, we want to take a look at what the impact on Canadian business is. So what we'll cover today is background, privacy officer. Well, you can read this. I don't need to read this for you, but it kind of touches on all aspects of the obligations that businesses are going to face if you do business in Canada. So a little background is Quebec on September 22nd passed Bill 64. And Bill 64 is actually designed to impact 21 acts in Quebec, but our primary focus today is the act respecting the protection of personal information in the private sector. There is another bill for the public bodies that is heavily impacted as well, and we'll cover that in a different session. So just as California sets the bar for privacy and data protection in the US, Quebec has stepped up and done the same thing here in Canada in the wake of our federal government not being able to update, or I shouldn't say being able to, not actually updating PIPEDA. The provinces are stepping up. So BC was first, I believe, Alberta, Quebec, and Ontario is about to step up with probably a very similar law to Bill 64. I'd like to just, for those familiar with it, this is a very GDPR-like law. And if you're familiar at all with privacy and data protection, GDPR set a new global standard for data protection and privacy, which has kind of influenced lawmakers around the world. So at the core of this, less about compliance and more about, do your customers trust you? So do your current data practices consider their best interests? Or, you know, at the last 20 years, we've really taken care of our own best interests, and sometimes at the cost of our customer or our consumer. And I think we maybe didn't stop to think how that might affect our brand in the long run. And I think all the studies we're seeing say that if a customer doesn't trust you, they're not likely to buy from you. So let's look at this. I love the way Quebec did this. They had 3 stages of coming into force, from September 22nd, 2021, when they passed the law, to September 2022. So in 10 months from now, there is really 2 key pieces coming into force. So the first is that you must appoint, and it's interesting that they did this very intentionally. By the highest position of every organization, in other words, the CEO, will be the person in charge of the protection of personal information. They can delegate that to a privacy manager, but that person should have a direct report to the CEO. So what this tells me is that they're going to hold senior executives, the most senior executives, accountable for the care of personal information within the company or within the organization. The privacy officer must ensure that the organization implements and complies with the act, while they must also publish their information on the organization's website. And that's not buried in 6-point mouse type. They want you to be transparent. So our recommendation is to act now, appoint your chief privacy officer, and make it public, and make it easy for people to reach that person. Next, we'll talk about the second piece that's coming into force in that stage one, and that's the confidentiality incident report planning. So right now, that is in the law in PEPITA, but not terribly enforced. What's going to change in the marketplace is that the CAI, the Information Office in Quebec, will enforce this, and they have been granted the powers of enforcement, which we'll talk about later. So under this new law in section 3.5 to 3.8, the organization must notify the CAI when there's a confidentiality incident. And they do actually have a definition of a confidentiality incident in the law. And it's either a security breach or even just a mild data breach. So they're all clumped together in what they're referring to as a confidentiality incident. And they're particularly interested in the ones that have a risk of serious injury to an individual. PEPITA calls that the real risk of significant harm. The province of Quebec refers to it as the risk of serious injury. And so the things you have to weigh when you have a data breach of any kind is the sensitivity of the information concerned, the anticipated consequence of its use, and the likelihood that such information will be used for injurious purposes. So the tough part of this is that organizations now must A, have a written plan, and B, must have a register of breaches. So that if the CAI comes to you and asks for your log of all of your breaches for the last few years, and you can't produce it, it's very simple. It's here's your fine. So, excuse me. So our recommendation is to develop and implement a compliance plan within a 10-month deadline. That's not very erroneous. That's pretty straightforward. We have clear policies and procedures for a reporting plan, and we are in the process of programming an online SaaS portal to track and record all confidentiality incidents in a secure environment. Excuse me. Stage 2 of coming into force is a lot more complex because stage 2, just about all of the other aspects of Bill 64 come into force. So that's in 22 months from now, September 2023. So like I said at the beginning, I love that they've staged this in a way that, you know, it's like, how do you eat an elephant? Well, one bite at a time. So here, take care of the most important thing. So it tells me that Quebec thinks that data breaches and getting a handle on it is a very important first step in securing individuals' data. So Privacy and Procedures Manual, section 3.2 says that you must establish and document, implement policies and practices regarding the protection of personal information. So it's not just the protection of, but it's the collection of, and so your policy and procedures should state very clearly how you collect data, what you do with it, who you share it with, and we'll get more into that as we go on. They must provide a framework for keeping the destruction of information. So what's your retention strategies? It must define the roles and responsibility of the members and its personnel throughout the life cycle of that information, who can touch it, who can't, and provide a process for dealing with complaints regarding the protection of the information. You must publish detailed information about these policies and practices on your website. So we are talking to some clients who are willing to actually post their policy and procedure manual, so that there's like 100% transparency is really, I think, what the CAI is looking for. Start documenting your privacy practices. We're working with the Data Collaborative Alliance to create an automated solution to complete with templates. So, stay tuned on this one. This one's a very interesting project. Most people don't have a policy and procedure manual only because they don't know where to start. And this initiative with the Data Collaborative Alliance could give you a very clean, templated way to start building your manual and then customize it to yourself. Privacy impact assessments. It's interesting to note that first arose in the GDPR, and that the new Quebec law insists that privacy impact assessments be done when acquiring, developing the redesign of any information system or electronic service delivery project or product or service. They're basically saying do a weighing analysis of the proportionate to sensitivity of the information, the purpose for which it's being used, and the amount and distribution and format of the information. They want a company or an organization to completely think through the privacy and data protection implications of what they're building. So again, I don't think they're expecting you to go back and do it for every process you currently have, but any new process that comes up, or if you any change in technology, they want you to file a PIA and be able to prove that you thought it through and that you really did consider the individual's privacy. And again, on this one, because of GDPR being so far ahead of us, GDPR was introduced in May 2018, so it's been in the market for 3 solid years. We have a pretty good idea of what PIAs look like and how they're thought through. The next area in stage 2 is transparency, and it looks like they're real serious about no more trickery. When you collect people's data, you have to be upfront. So they're saying that organizations must provide the following information upon collection and again upon request. So the purpose of the collection, the means of the collection, the rights of access and rectification. So you need to inform individuals that they can access and change and update their information, and the person's right to withdraw consent to the communication or use of the information, even though they agreed to it in the first place. So that right to withdrawal is a very key part of the GDPR, and it's now going to be alive and well in Canada. If applicable, the following information must also be provided. So if you are sharing this with third parties, you need to state who they are. You need the categories of third party, and you have to identify information that's being transferred outside of Quebec. So there, unlike the Bill C-11 that was proposed to replace PIPEDA, which did not mention transferring of data at all, Quebec has aligned with the GDPR and said if data is transferred to another community, it is your responsibility to understand the rules in that community, and if you are putting a person's data in harm's way, you're accountable. So interesting. Must also have a privacy policy on your website, and it must be in clear and simple language. So no more lawyers writing complex privacy policies that you have to reread several times. So a recommendation here is that we look at all of your collection points, your web forms, and we start changing the language to comply. And we have marketing write the privacy policy. Certainly legal should be checking it for accuracy and to protect the company, but it should be written in a friendly way. Transparency. Now, this gets interesting. Profiling, geolocation, and identification technologies. So organizations must inform individuals of any collection of personal information using a technology that includes functions allowing the individual to be identified, located, or profiled. So the way Facebook currently does it does not give me comfort that they're going to be welcome in Quebec. So they're going to have to change their practices in order to operate under this law, because they do a significant amount of profiling, and they're not always really clear about what profiling they're doing. Nor are a lot of other companies. So I don't just mean to call Facebook out. They're just, the biggest bad boy, if you will. Organizations must also inform individuals of the means available to activate such functions. In other words, if you're using algorithms or machine learning or AI, you have to be upfront about it. And again, they defined profiling. It refers to the collection and use of personal information to assess certain characteristics of a natural person, in particular for the purpose of analyzing that person's work performance, economic situation, health, personal preferences, interests, or behavior. So that's a pretty broad definition that scoops up pretty much any online profiling that we're seeing happening in the data world. We've how would I say it? We've gotten carried away with people's personal data, and we're being severely reined back in by these new legislations. So again, the recommendation here is, over the next 22 months, review your practices in these areas, document any gaps, and begin to close those gaps. So while it might feel a little daunting sitting here, if you start to just take bites out of it and start to take the key pieces, the stuff you're most likely to get fined for. Now, we don't know what that is. We have no guidance yet from the Quebec CAI or from the Quebec government or the regulators, and we have no regulations which will follow. There'll be a couple places in here where you'll see that regulations are forthcoming. I did a whole webinar just on consent, but trying to cover it at a high level. Any individual who provides their personal information after receiving an adequate privacy notice is deemed to have consented to its use and communication for the purposes indicated in the notice. So that's pretty clear. You have to be very transparent. And it must be clear, free, and informed, and be given for specific purposes. If you're going to use it for any other purposes, you have to circle back and ask for consent. So unlike the GDPR, which has 3 lawful bases for processing for the private sector, Quebec has decided to go with consent only. Sorry, I'm going to correct myself, consent and contractual. So the one missing is the one we do all our direct marketing under the GDPR, and that's legitimate interest. And there is no allowance for legitimate interest within Bill 64. It's only got 2 options, consent or contractual. So it's going to make it much more difficult to use email or online methods to communicate with people without clear, free, and informed consent given for specific reasons. So it's going to be tough. It's more like CASL. CASL was the first law in the world, anti-spam law, to take actually the hardcore position of you require consent of some form, and then they gave some options on what that consent looked like under CASL. But Canada is the only opt-in consent-based regime in the world. Almost everybody else is an opt-out. So you can email me, but you must give me a chance to unsubscribe, and you must honor it. This is the first time they mentioned minors under 14. It's a common thread throughout. Quebec has deemed that 14 years of age and under is the minor age, and they've got a lot more stringent rights. Do your homework, find out the best preference manager center to deploy. it's clear to me that preference management centers are going to be an absolute must for any organization in these new data protection and privacy regimes. It's amazing how you can actually open a portal to your consumer, allow them to turn off and on different consents, and tell you exactly what they have, so that you have a log back 6 months ago. Your consent was this, it's changed to this, but when we're being investigated, the period we're being investigated for, we actually had consent and we can prove it. So trying to do this for in any manual way is just, I think, absolutely insane. So automating this process and then honoring it will save significant time and resources down the line. So we went online and we looked at who the best preference management centers were, and did probably close to a year's worth of the investigation, and we partnered with CASI by Serenus. We believe that is the strongest solution out there and most flexible, and you know, it's not cheap, but it's worth it. So as I say here under the recommendation, do not get fined for data you don't even use. So one of the first things you might consider under these new laws is what data are you currently holding that you're not even using, and you can just delete it. And I know the hair on the back of your neck stands up when I say delete data, but there is an awful lot of data not needed. We had one client that is about 21 years old, and I said, "What's your data retention strategy?" And they said, "Data retention." And I said, "Yeah, how long do you keep the data for?" And they said, "Forever." I'm sure that who they did business with 21 years ago is not relevant at all today to who they do business with today. So interesting. We developed some policies and procedures that allowed for, after 3 years, your customer file was, if you haven't bought anything in 3 years, your customer file was zeroed and you were treated as a new customer coming in if you came in after 3 years. So it's just making those kinds of decisions, documenting them, and training your staff. That's really what these laws are requiring. They did build, like the GDPR, privacy by default, or privacy by design and default into this law. So bring privacy and security, IT, into your product development process right from the beginning. So I'm on a ISO 31700 committee. We just designed the privacy by design for consumer products, and it's basically, when you're doing product development, how do you bring privacy in right from the beginning? And it's a new ISO standard that'll be out this year in 2022, and I think that it's going to start setting a trend. What they're asking is that you really think through the implications of having and using people's personal data. Section 12.1 covers automated processing, and again, this is controversial. This is AI. This is algorithms. This is using. This is credit bureaus using a completely automated system to make decisions about credit. They're basically saying that there's got to be a human element in it. So examine current practices and document your gap report, and then decide how and when you'll close that gap. And you've got 22 months to do it. So you could prioritize. So if you just sit down and look at your gaps now and create a project list and put timelines and responsibilities to it, you can be very compliant with these new laws by the time they actually come into force. And the cost of not doing it could be that you're like there were people made examples of under Castle. You could be one of the people they make an example of. Again, cross-border transfers, we touched on that a bit, but you have to really, any data going outside of Quebec, you have to do a privacy impact assessment, and you have to be aware of what the applicable legal framework applicable in the state in which the information will be communicated. So if you're sending it to the states, you have to be accountable for understanding what can be done and can't be done with that data in the states. And if it's really in conflict with Quebec's law, or this new Canadian standard, if you will, this community, you'll have to reconsider whether you should be putting it at risk, because you could be held accountable if you put it at risk without forethought. And so again, examine your current practices and document a gap report. And then you just schedule what you're going to take on first. You start to prioritize things. So I think compliance under this bill, while yes, it's a change from how we've been doing business, it is how we should have been doing business. So it's just asking everybody to get up online and start to treat your customers' personal information like it belongs to them, not you. That you're merely a custodian, and during that period which you hold it, you will respect it and do the right thing with it. So that's really, if you think about it, all these laws are simply, they're actually legally having companies take good care of and respect their customer, which is kind of mind-boggling to me as a marketer. That's what marketing is all about, and somehow we let this really get out of control the last 20 years without thinking about the implications. So these laws are forcing us to think about the implications. Retention and destruction is a big deal in this Bill 64. So Section 23 of the Private Sector Act is basically asking you to, when the purpose is done, that you have consent for that data, destroy it. So if it's outlived its purpose, you have to get rid of it. So again, it's just thinking through what's the value to the company and what's not. And again, you don't want to be fined for data that is absolutely no use to the company. And our experience over the years is the stuff that gets you in trouble is the stuff you're not even using. The stuff you're using, you're probably doing a good job and being respectful, but the stuff you're not using is where the real cost of data breaches are. So again, examine your data on file and its use, and delete any data not being used for a specific purpose. Or if you wish to continue using that data, contact those individuals that you do not have clear consent for. Now, remember, I bringing clients into castle compliance. They're willing to claim that they have consent, but they're not able to prove it. And if you can't prove it, it doesn't exist. It's really simple. So documentation under these new laws is really critical. You have to be able to prove that on a particular date that you're being investigated for, that you had clear consent for a specific purpose to use that data. This one's a little controversial. It's a de-indexation, right? So individuals may request that organizations cease disseminating their personal information and de-index any hyperlinks attached to their name that provides access to the information if the dissemination contravenes the law or a court order. So again, this could change some of the activities over at Google, but we'll have to see what the legal implications of this are. I'm just a marketing guy, so I'm not really schooled in the the depth of the legal implications of this particular section of the law. And then, so that covers quite a bit. And I think, you know, things like de-indexing and these last few, I again prioritize. So they dealt with the most important things up front, like consent and protection. So you want to prioritize and give yourself the best shot at being compliant in September 2022 with these laws, with the most important parts of these laws, the ones that we think are going to be fined for. Data breach is definitely number one. You're going to see fines next fall, early winter. So around this time next year, you're going to see fines for confidentiality breaches. I can almost guarantee it. They've made that in stage one intentionally. So there seems to be a lot of concern, both, you know, in Canada and the US. Under the White House seems quite concerned as well about the need to really get a clear handle on data breaches. And one of the best ways to do that is to force companies to keep a register. So in 2024, the final piece, data portability rights. So they're giving organizations, large organizations, a little bit of time to basically store and be able to transfer data in a structured, commonly used technological format. So if you want to switch all your banking from one bank to another, they can't be speaking different languages and terminologies, and so there needs to be some interoperability between competitors. So in insurance, same thing. If you want to transfer your insurance, they have to be able to give your file with meaningful information in it to your new insurance company at your request. So again, this was introduced as part of the GDPR and has certainly caused some angst amongst the large enterprise companies who have used how they keep personal data. They've used it as a little bit of a weapon to keep you doing business with them. So examine your current practices and document your gap report, and then decide how well you'll close that gap before 2024. Because this affects, you know, embedded legacy systems in some of these big organizations, this could be a significant chore for them. So can't really talk about this new law without addressing enforcement. So I just want to be able to give you a kind of high level what administrative monetary penalties are in play, what they mean by penal offenses, because the administrative monetary penalties go up significantly for penal offenses. So we'll dig a little into, you know, what that definition is, and then we'll look at their private right of action. So Borden Ladner and Gervais, the law firm, a very good Quebec-based privacy law firm, put this chart out, and I thought it was just an excellent visual summary. So the violation on the left is collection, use, disclosure, or destruction of personal information in contravention with the Act. So if you don't properly collect or destroy or use, it can be considered a penal offense. And in that case, it's a 25 million or 4%, up to 25 million or 4% of your worldwide turnover. That's a significant amount of money. So the fines are in the same ballpark as the GDPR, even though nobody's been fined to the full extent yet. But I think patience is running out on some of the tech companies in the EU, and you're going to see some massive fines in 2022. They've used lawyers and teams of lawyers to throw out all sorts of blocks, and I think that the data protection authorities over there are just getting fed up, and some of these investigations are going to come to a close, and you're going to see some significant fines in the EU for organizations like Facebook and the big tech players. So stay tuned on that. That's my prediction based on all the rumblings I'm seeing to date. So you could also, the collection, use, disclosure, and destruction of PII can also be just an AMP, and that's 10 million or 2% of worldwide turnover, still a significant amount of money. And it is subject to the private right of action. So damages can be awarded, though I believe, I haven't delved too much into the private right of action just because it's a little ways away from coming into force. That will be basically well, it might affect the stage one, because if people are affected by a data breach, they could be awarded damages, and there could be class action lawsuits. So, I should probably get a clearer picture of the private right of action and what's allowed. Under Bill C-11, the private right of action was a complete thumbsucker. You had to, you couldn't launch a class action lawsuit under Bill C-11 unless the tribunal, unless the Office of the Privacy Commissioner had found the company guilty. Then the tribunal supported it and fined them, and they've survived appeals of both of those. So, it could be a 4 to 7 year legal period before a private right of action could even be launched. And then the real kicker of the private right of action built into C-11 was the fact that you had to prove damages. And any lawyer will tell you that proving damages in a data breach environment is next to impossible. It's a very high bar to meet. Castle, when it introduced the private right of action, it automatically assessed a $200 per incident damages. So you didn't have to prove it. It assumed that you had at least $200 per incident. So if you had the Bay sending you 100 emails that you could prove were spam, and you were suing the Bay, you would get $200 per email for the 100 emails. That private right of action had teeth. So the one in Bill C-11 had no teeth at all. So there was enough there to say there was a private right of action in the law, but it really wasn't a private right of action. You would have never seen it exercised, and if you did, it would be by very patient people trying to prove it at the set of precedents at the Supreme Court level. So retention of personal information in contravention. So it's basically not honoring your own retention strategies can get you an AMP or can result in a private right of action. Failure to provide an appropriate privacy notice can be an AMP or a private right of action. Failure to notify the CAI or affected individuals of a breach. So if you have a breach that has some serious implications and you haven't notified the CAI, that can be considered a penal offense. It'll just depend on severity, whether it's a penal offense, an AMP, or a private right of action. Failure to inform the individual concerned by automated decision. So that whole piece of the law and being transparent about it, that's AMPs or private right of action. And then actually refusing to cooperate with the CAI if they investigate you, and failure to comply with orders from the CAI could be considered penal offenses. So that's pretty strict. We've gone from PIPEDA that's not enforced at all, or hardly, to one that looks like it's going to be enforced aggressively. So the history of the CAI has been that they're not afraid to swing outside the borders of Quebec, and find a Canadian company that's keeping some data on Quebecers. So given that it's impossible to maintain a different strategy for all the other parts of Canada and then just have a Quebec strategy, it would be so confusing to your employees and your third party and third party partners, as well as to your consumer, which is probably the main one. You probably just want to pick the highest bar, and right now in Canada, that highest bar is Quebec. What I like about this is that Quebec, like they did in 1993, they're forcing the federal government's hand to put a law that matters in place. So if the changes to PIPEDA are not as high a bar as Quebec has set here with Bill 64, then the Bill 64 will rule. So companies will have to operate to the toughest law in the land, just like they do in the States. With California is the toughest law in the land in terms of data protection and privacy. So that becomes the de facto standard that any organization has to operate to. So don't look at it, I'm like, do I have to comply to Quebec's law? Look at it that Quebec has set a new standard for Canada, and that our program should be in line. And really all they're asking us to do here is to respect the consumer and take care of them and protect them. And we haven't done a very good job of that in the first 20 years of what we would consider digital marketing. So now we're being regulated into it, which is kind of ironic. So this brings me to avoid unhappy customers. So if you can change your data and privacy protection practices over the next couple of years, you'll not only avoid the fines, but you'll begin to build trust with your customers again. Because right now we're in a trust deficit with the consumer across the board. I mean, there are very few brands that most consumers would actually trust their personal data with. And we have to change that. And these new laws are designed to change that exact issue. So most of them are put in place to begin to rebuild trust. And as corporate America, yeah, we make more money if we take advantage of them, but we have to consider, where's the line, and then not cross it. So that is the end of the formal part. And if we can help in any way, please let us know. That is the business we're in. We help organizations implement privacy management programs that are to the standards that the organization wants to operate at. So for example, if we encounter an organization that has used the NIST cybersecurity framework to set up their cybersecurity, we recommend that they use the NIST privacy framework to do their privacy program. And we're perfectly comfortable using either privacy by design, the NIST privacy framework, or the ISO standard of 27701. So again, we have clients who have put 27701 in place for cybersecurity. They would want to put 27701 in place for privacy. So it's a changing world, and we have to start paying attention. You don't have to go to the extent of being certified by ISO or NIST, but it may help in terms of that earlier discussion of public trust again, so that being able to display this, that you're NIST or ISO certified in privacy, could actually be a contributing factor to you're doing business going forward. And I think you're going to start to see, I think you're seeing a great awakening at the moment from the consumers. They're beginning to understand that this isn't just about somebody having my email address. This is about somebody, seriously profiling me and only feeding me my own biases, and you can see the damage it's doing to society. You need only look in the the most visible example is the U.S., but we experience it here in Canada as well. There's getting to be a divide between the right and the left, and it's not quite as pronounced as the U.S. But I think that a big part of that is we're only being fed the kind of information from social media that our profile tells us we're interested in. Give you an example of that. During the last federal election, I'm been a conservative all my life, and I won't apologize for it. And I certainly allow that there's liberals and NDP and lots of other Green. There's lots of other belief systems in place, and I've got room for them. And some of their arguments are legitimate, and some I think are kind of ridiculous. But what I noticed is my commenting and liking and sharing on LinkedIn about anything that was conservative versus liberal or political in any way, it got picked up on. So going into the election, it looked clearly to me like the conservatives were going to win that last election. But after the election, I realized how much of my own Kool-Aid I was drinking. And because that's all they were serving up on my LinkedIn feed. I wasn't getting any positive liberal stuff at all. And I think that LinkedIn's definitely not the worst at this. I must say Facebook and their platforms are extreme at this, because they're all about engagement. Because through engagement they sell more advertising, and it's a pretty simple model. That's all up for grabs under that profiling capability. So no longer will the ad community be able to take your personal data and transfer it to literally thousands of potential advertisers in a real-time bidding process, where they're bidding to put their ad in front of you because of certain qualities in your 5,000 data point file that's being transferred all over the place without you understanding. And it includes sensitive information under the GDPR. So things like your sexual orientation and some of your health. So they know if you're on metformin that you're diabetic, and that's in your file. And quite frankly, for the most part, I don't think that's anybody's business. So these laws are going to start clamping down on this profiling without consent. Now, if you give consent and you don't care what they're doing with it, or you're not clear about it, but you still give them consent in exchange for having an account or whatever, that is your choice, but it has to be a clear and transparent choice in today's marketplace. It can't be buried. It's funny. I don't know how accurate this is, but somebody told me that Facebook's privacy policy was thicker than Macbeth, and you can't possibly expect somebody to read the terms of service and privacy policy and then go in and change all their privacy settings. These new laws are going to basically say your privacy setting is default to no, and somebody can turn it on if they wish. So the current status of these tech plays are that the default is set to yes, and you must turn it off. And the laws are saying no, other way around. So it's going to be an interesting time in the next few years. And I think Quebec's Bill 64 just brought this home to Canada. And so Canadian companies who have been watching what's going on in the EU for the last couple of years, last 3 years, and being mildly entertained by the hoops they have to jump through. The Canadian companies are now going to have to jump through those hoops. Now, in fairness, some already do care and have good privacy management programs in place, and they really do take this data governance, risk management. They take this serious, but the risk just went up significantly. With the ability for the CAI to fine, so the powers of enforcement have changed. But PETA is a very good law. It was way ahead of itself in 1999. It's still relevant in many parts today, but it's just the enforcement of it is just way too expensive and erroneous, and takes way too long. It takes 5 to 7 years to have an enforcement go through the courts and be appealed and all of that under PETA. CAI I don't think is going to end up like that. They're going to be able to, like the CRTC hands out fines under Castle, CAI are going to be able to hand out fines under Bill 64. So that about wraps things up. If you have any questions that I can answer, I'm happy to do so. And if not, we'll wrap up 8 minutes early and give you back 8 minutes to your valuable day. So I don't know if anybody on the call has any questions, but I'm happy to give our best answer. One of the things that we just built under the Bill 64, I mentioned earlier, it affects 21 acts. That two we're most concerned about is the public body's personal information and how they manage it, and the act that affects the public sector, or the private sector, sorry. And we have built a very interesting spreadsheet, which I will share with you, with the Data Collaborative Alliance in an effort to post, let me just find the document here first. In an effort to post the current PPIPS, because the current one online is a 2007 version. So let me just get my screen up here. So this is the act respecting the protection of personal information in the private sector, which is what we've been talking about for the last hour. And Bill 64 has a significant amount of changes to this act. They also have a significant amount of changes to the, so here's the screen I wanted to show you. This act that I'm showing you here is the language from 2007. So they have not yet incorporated online the new data, if you will. Like the act I'm reading here is not up to date. So what we did was we built, and I think some of you will like this, we built a spreadsheet that we are going to use some very impressive technology tools to make available to the public a document that basically, so let me just explain what we did here. So we took the act for the private sector by each division. We put by each section what the 2007 version was. So this version here. So literally by section, what the act currently says, what Bill 64 is required and has passed to change. Therefore, what's the new version of the 2021 version of these the act respecting the protection of personal information in the private sector. Then we went on to put some tags so that if you wanted to search for the purpose of the act or the scope of the act, it would take you right to this section. So we provided all this information, and it was a significant amount of work, but we provided this to the Data Collaborative Alliance, and they are going to post it in a way that's really usable by companies who are concerned about the wording of the law and can look. For example, they can look up policies and procedures, and here is the section that deals with what you have to do around policies and procedures. Privacy impact assessments, here's the first time it mentions it, but there may be other times that mention it. So in this document that the Data Collaborative Alliance is producing for us as we speak, you'll be able to actually see what the new PPIPS is, all the new language. So it incorporates every change to Bill 64 made in the law. And again, you can see it was a significant project right down to the end. So it's, again, if you want more information about this, stay tuned to the Data Collaborative Alliance. And we will be promoting heavily that you can find out the details of the effect of Bill 64. We are in the process now, having done this for the private sector law, we're in the process of doing it for the public sector law as well. And the public sector law deals a lot more with the access to information than the collection and use of. So it's a completely different bill, but it's amazingly similar. So the breach notification piece is exactly the same under the public bodies as it is the private sector. So again, we might actually include a column in doing the public sector one of where it overlaps with the private sector. But make no mistake, the GDPR said we're not going to distinguish between the two sectors. It's one law for the country. So people know that their data is protected, whether you're government or private sector. Quebec didn't go quite that far because Canada and Quebec both have both. So under PIPEDA, we have the PIPEDAs for the public sector, and we have the Privacy Act for government. So we kind of have a long history of separate laws for those two, but pretty impressive with how much they actually align. So there's not a lot of things that they can do in the public sector that the government can get away with. So again, I thank you for your time today. We are 2 minutes away, and with no questions to answer, it tells me that I was pretty clear on the presentation today. So if you would like a copy of the presentation, please reach out to me. I'm dlackey@newportthompson.com, and I would be happy to send you a copy of the information. A recording of this will go up on the Response Marketing website, as well as on the Newport Thompson website. So thank you. Have a great day, and stay safe.